Memorial Day edition of our channel by Andrew. If you can hear me acting like a damn fool, give me a thumbs up so I can get that check call out the way. I need to get that check call out the way. I need to get that check call out the way. Nah, thank you, Shorty. Shorty done called on. She know how to get it done. What's good? What's good? Hey, Red Bunny, you were first. Woo! Hey, Shorty, what's good with it? Liar, liar, what's happening? Hey, Leslie Jennings, Samantha Nicole. Hey, Candy. It's like candy. Ow. Can you feel it too? What's good with it? Oh, I am in such a good mood. Y'all, happy Memorial Day, everybody. And thanks for the service of those here and fallen. Thank you, thank you. You know, my dad was in both the Army and the Marines. No, I love my dad. Mm-hmm. So, I wasn't coming on here today because, I'm still on what's the name, on a little short vacation. But I saw some stuff. Hey, that's hey, Leslie. I think I did. But I saw some stuff and I wanted to weigh in. First, R. Kelly did a declaration, and I don't see that it was read. I don't know if anyone read it yet, but I'll go ahead and read that and get it out the way. As well as what that dude name is, Derek McDavid, put in a request for traveling. Okay, so let me get this R. Kelly declaration out the way, because y'all love words from R. Kelly. We're going to bring you some words from R. Kelly today. My. This is from R. Kelly. I'm not on the screen, but I'm going to read this from R. Kelly. Okay. Now, this is his declaration, right? And so, this all kind of ties in together a little bit today, right? Because remember, J-Bo, McDavid's attorney was saying like J-Bo didn't have any evidence as of what she was saying as far as like what about that day, the R. Kelly old attorney that died and the other lawyer that was working with him and what have you. So R. Kelly has submitted a declaration to attest to some of those points, right, that J-Bo had in her paperwork. And we do know that we accept, I'm not saying we don't work there no more, that they accept this form of testimony as testimony, right? So as evidence. So this is what we have. So this is a declaration of Robert S. Kelly. It says, I, Robert S. Kelly, declare under penalty of perjury. Remember, this is the other way that someone can be held under contempt for perjury, right? Written is under the penalty of perjury. Okay. Number one, I am the defendant in the above captioned matter. Number two, I am aware that my attorney filed a motion for severance in this case after numerous conversations with me, and she has read the motion to me. Number three, I was represented by Ed Jensen for many years in connection with an investigation and eventual child pornography charges brought against me by the Office of Cook County State Attorneys in the 2000s. Number four, Mr. Jensen and his partners, associates, colleagues represented me at trial on those charges that ended with an acquittal on June 13, 2008. Number five, after that acquittal, I maintained an attorney-client relationship with Mr. Jensen for at least a decade, including between 2012 to 2018, which included regular consultation and legal matters in my life that came up on a frequent basis. Number 6, I am also familiar with the Sun Times article in which Mr. Jensen was interviewed before his death. Without getting into detail, Mr. Jensen revealed attorney client privilege communications in that interview that I did not authorize. Number 7, I did not file a complaint against Mr. Jensen with the ARDC, and the ARDC never contacted me to discuss Mr. Jensen's comments to the Sun Times. I have no idea whether the ARDC ever conducted an investigation into and violations of the rules of professional responsibility by Mr. Jensen. Number 8, although I do not have a specific memory of ever consulting with Vadim Glasman, I have a distinct memory of his name as someone who worked with Mr. Jensen, during the time that I continued to consult with Mr. Jensen about legal matters following my 2008 acquittal. I declare under penalty of perjury under the law of the United States of America that the foregoing is true and correct, executed on May 26, 2022. 2022. I don't understand. I can never say that shit. So, that is from R. Kelly. Okay? And so that's directly related to this motion to sever, right? Where you could see, and I'll read, this is from that attorney, right? From Mr. McDavid. And that's directly related. So let me read to you this little area. It said, it is one thing to believe you deserve a continuance and disagree with a decision to deny it. That happens to all trial attorneys. It is even understandable for an attorney to be annoyed at the denial of a continuance and those who oppose it. But it is another thing to altogether to manufacture the need for severance from a patchwork of bare allegations that recklessly impugn the integrity of respected members of the bar and falsely malign and co-defendant, while presenting not a shred of actual evidence that supports these sweeping contentions that were made with neither tact nor tether to reality, right? So I read that, and I'm glad I pulled that up for a reference, right? To reiterate to you once again that these filings, as well as the indictment, are all allegations, right? Until proven out in court. They're all allegations. Okay? So what I'm saying is, until someone proves that they are true, and they 9 out of 10 do that during a trial by some type of evidence. I mean, testimony is definitely evidence, but direct evidence or physical evidence is also is the best form to support what you're saying. But they will accept that declaration of Mr. Kelly, right? So I said that to say this. So I was minding my own business, and I just got finished listening to Atmos live, right? And we're back on these text messages. And he had pulled up a document. He said, go read for yourself and all of that and whatever. And I did, because you can't remember all these documents and all this shit. Just can't remember all this, right? You know, what it said and whatever. Some people can remember certain areas of it, but some people can't. So I went to read, I saw his head, and I thought that it was some kind of smoking gun with the text messages. And I was like, great, we're going to get to that. And he pulled up the document, which was the motion in limine, that was submitted by the government. And he read the area in there that kind of deals with the extortion. Once again, the extortion has nothing to do with those text messages that's related in that J-Bo offered up, in her file. And again, I just read to you what another attorney said, specifically about J-Bo, that she does not present evidence to confirm what she's saying. So that tells you that you can submit these files, whether it be the government or the defense, and not have evidence right there along with that filing to prove what you're saying. With pretrial motions and stuff, you have to prove that in court. You have to have that evidence. You have to go through that. They go through that discovery and turn it into evidence, right? So listen to this. I don't know how the translation is getting lost. So when you look at something, when you pull up something, you got to pull up all the pieces and the parts and all of that. And when you are also giving it to an attorney to look at, you have to give them all the pieces and the parts. Because if not, it's not going to make any sense. And they're going to probably give you an answer that's consistent to what you're trying to say or to your narrative, right? If you don't give them all the pieces and the parts. Again, we went through it, right? Over here. And the extortion has nothing to do with those text messages that J-Bo was offering up. J-Bo was offering up those text messages to prove that that's directly related in her narrative. Okay, let me say that it's her narrative that's directly related to proving that it wasn't R. Kelly doing the inducing and coercing and all of that. It was the Jane Doe number 5, and her parents was in on it. The extortion. Now listen, you gotta take it from me. I'm gonna show you the paperwork, all of it, and I'm gonna show you what the judge addressed with regards to extortion. So it's going to poke holes into Atmos's theory. Okay, that's what I'm gonna call it, a theory. All right, I understand. I don't know who all needs to be. I don't know if it needs to be a pledge or a written whatever for everybody to say that the parents, Jane Doe number 5 especially, it ain't really good parents. They made a whole bunch of missteps and mishaps, but it seems like their relationship with her and her parents is on a good road. And that's the only thing that matters, right? That's the only thing that matters. But it was a lot of fuck shit was done. Okay, but let me put this together. So we're going to go through this again. I don't know how many times we have to do this, but as much as, and this is when you look crazy, right? When you don't stick to your guns and let others push you up and fill your head up with bullshit because they have some kind of weird obsession with this bullshit. I don't know what it is. And I'm going to say what the fuck I'm going to say. That's just what it is. So here we go. Now I'm going to pull up to you. I'm going to pull up what Atmos used today as evidence, right? It was this one. Okay. Pull up what he used. Because at this point, this should be like common sense or I don't know what the fuck it is. Okay. Let me break this down a little bit. Now, it says the defendant should be precluded from making legally irrelevant and prejudicial arguments regarding the parents of certain victims. Okay? Certain racketeering acts and substantive counts allege. Okay, so let's stop right here. Just because the prosecutors have it in discovery, they have to include any evidence, that any discovery that may be exculpatory, and of course inculpatory is going to be in there, but exculpatory, right? It doesn't mean that they are saying something one way or the other. Once you get that discovery in, during this phase of it, when this motion of limine was drafted up, they are in a phase where they are crafting their defense. Okay, that's what they're doing, crafting their defense. The prosecutors have crafted their prosecution. Okay, so it says allege that the defendant coerced minors, including the individuals identified in the indictment as Jane Doe number 1, Jane Doe number 2, and Jane Doe number 5. Right there, it tells you. Now, before I continue to go on, it doesn't say anything about them fucking text messages. Okay, it doesn't say nothing but they are trying to shut down a defense. Doesn't relate to just Jane Doe number 5. They're talking about 1, 2, and 5. So they're trying to jump in front of this and shut down a defense, because what happens is the defense takes whatever they have that's in that discovery and they try to piece it together to make a defense. Apparently, the prosecutor had some evidence that they were, and I'll tell you where they got that from, that they were going to use the stuff that I'm getting ready to read to say that there was some kind of extortion by the parents. Okay, well, you'll see where that was later shut down. And you'll see that the extortion was not, it had nothing to do with them damn text messages. It had something to do with testimony. I'll show you that in black and white again and again and again. Let's go. It says to engage in sexual activity prior to their being old enough to legally consent to such sexual activity. To prove these offenses, the government expects to present evidence showing that Jane Doe number 1, approximately 15 years old, Jane Doe number 4 at 16 years old, and Jane Doe number 5 at 17 years old spent a substantial amount of time with the defendant, despite having not completed high school, and that the defendant may try to, not will, not I got the dead with evidence, may try to. They're trying to shut down a defense. Okay? And let me tell you this, just because you have a defense, or whether it's if it's the prosecution offense, right? Or their prosecution, it doesn't mean that it is true until you bear out all the facts and support it with some type of evidence. We'll get into that. It says, where was I? Deflect the blame for his criminal conduct by offering evidence that the parents of Jane Doe number 1, 4, and 5 knew or should have known about their daughter's sexual relationship with the defendant. The defendant may further assert, okay, they're shutting down a defense, a narrative, not the truth, but a narrative that hasn't been proven truth or false, but they're shutting down a narrative. Knew or should have known about their daughter's sexual relationship with the defendant. The defendant may further assert that to the extent the parents of Jane Doe number 1, 2, and 5 knew or should have known about their respective sexual relationship with the defendant. The parents thereby consented to such relationships. Now, you know that this is just a defense narrative because you know that a parent can't legally consent to nobody having sex with their underage child. That's how you know that the prosecutor wasn't not alleging that extortion went down. They are just saying this is the shit that may be coming. They are trying to get the judge to shut that down because in fear of all of this, plus the dildo shit and the legal motherfucking business offers and shit, if they get the parents on the stand and all and ask the, you know, ask the craft their questions where it may look suspicious to the jury and will only confuse the jury. That's what they're trying to shut down a defense. This is not proof of shit. That only that they trying to shut down a defense. Know your shit before you present it. Let me keep going. Even assuming arguendo, meaning for the sake of the argument, that there was evidence to support such claims, even assuming there was evidence, meaning there is no evidence to support such claims. That's what they say. Let's keep going. The evidence would have no legal bearing as to the offenses with which the defendant is charged. Indeed, consent by either the parents or the underage victims is not a defense to such charges. Accordingly, the defendant should not be permitted to elicit testimony from the government's witness, including Jane Doe number 4 and 5, during cross-examination, introduce evidence or argue that the parents of the women and girls who the defendant coerced to engage in sexual activity were aware of, consented to, or were otherwise responsible for such activity. Such arguments are legally irrelevant and would only serve as a distraction to the jury. Meaning, just what I just said would confuse the jury. That's why you go through these processes in pretrial to shut down irrelevant defenses. Remember, I was talking to Sky and I said, not only would the judge shut out fucking irrelevant evidence and shit, they would shut down irrelevant defenses. Keep going. Such are, okay, I read that. Okay, so irrelevant, okay, it says federal FRCP 402. I'm sorry, Federal Rules of Evidence 402. Irrelevant evidence is not admissible. FR 403. Evidence is not admissible where the risk of unfair prejudice substantially outweighs any probative value of such evidence, meaning it outweighs the proof of such evidence. That's what it means. Similarly, the defendant should not be permitted to introduce evidence of any schemes by the parents of the victims to profit otherwise, extort the defendant on account of the defendant's relationship with their daughters. Specifically, Jane Doe number 5 has advised that her parents proposed certain business ventures with the defendant whereby they stood to profit if the defendant agreed to such business ventures. That we know, all right? They wanted to keep that off the stand because it would look like it was some kind of extortion, right? But they ain't got nothing to do with text messages. And while she was still 17 years old, encouraged her to take photographs of the defendant, which could later be used against the defendant, given in part her status as a minor. We don't know if that's true or not. The prosecutor isn't alleging that that's true. They start off by saying, they use all the words to tell you that this is the defense narrative. As discussed above, the actions of Jane Doe 5's parents have no legal bearing on the defendant's guilt as to the alleged crimes involving Jane Doe number 5. Accordingly, the government respectfully submits that the defendant should not be permitted to elicit any testimony or otherwise introduce evidence regarding any of the parents' involvement in business ventures or other means to profit from the defendant. We do know, if I'm not mistaken, I think, let me see. I know the father said it, and maybe it was somewhere else, that there was some kind of dildo and some kind of business shit or whatever that was offered up to the defendant, right? We already know that, right? Let me read these footnotes. It says, for the same reasons, the government respectfully requests that the defendant be precluded from eliciting during cross-examination, present evidence, or making arguments at trial, deflecting blame unto the parents of the minor victim witnesses discussed in government's motion regarding certain uncharged conduct it intends to present at trial, including the victim witnesses identified in that motion as Jane Doe number 7, 8, 9, 10, 11, 13, 16, 17, 18, 20, and John Doe number 1. And it says, there's a reference here. It says number 3 of the footnotes. It says, the government does not intend to call the parents of Jane Doe number 5 to testify in its case in chief. Should the government call any of the parents as a witness, the defendant should be permitted to cross-examine those witnesses about such conduct, given that it could be relevant to their truthfulness. Okay? Now, take that down. We're going to go here as soon as I find out where it is. Not that one, not that one. Not that one. I'm not on the screen, y'all. So if y'all ask me questions, I don't. Is it this one? Hold on. Yeah, it's that one. Now, talk about this fucking extortion. This is ridiculous. Get the help you need. Damn. Okay. Now, this document, I'm gonna show you right about the extortion. Right here. Right here. Number 3. This is on the page with them text messages. The motherfucking text messages. Right here, number 3. It says, although defense counsel sought to present evidence that Jane's parents intended to set defendant up and extort him, the court precluded that testimony. Testimony, not text messages. Testimony. That's what it was. You ain't got to believe me. Take it from the judge. You ain't got to believe me. Hold on. Okay. Now, let me look for that keyword, parents. Okay. Now, right here says the next category of evidence. I don't think you all are too far apart from this one either. Now, this is the judge. I done read this so much, I know who's saying it. This is the judge. This one has to do with evidence about the victim's parents and the allegations that they may have participated in the scheme to extort the defendant. This happened. This is her addressing that motion of limine that I just got off of, that Atmos say reference. So that's what I did. All right. The scheme to extort the parents. I don't understand that any of the parents are testifying. Is that correct? And this is the prosecutor. That's correct. This is the judge. So it's certainly appropriate if you know with a good faith basis to the question the witnesses, whether the witnesses participated in such a scheme. That's certainly appropriate, but sort of a general question about what their parents did is really not. I mean, there is no direct evidence of it. Talking about the extortion, there's no direct evidence, meaning no text messages, meaning nothing direct says that an extortion took place. That's probably why the defense didn't fight hard to get that, to use that in their let me see. It's probably why the defense probably didn't try to even allude to that, because much of what they were requesting to use was shut down. I just showed you where it said the extortion was testimony, right? I'm confirming. Hold on. It says, let me go back. It says, I mean, there is no direct evidence of it, so I don't know how the witness would know about it. Witness means somebody's going to get on there and talk about the extortion, right? Now, whether it been a parent, whether it been somebody else or whatever. Unless the witness participated in it, okay? Then you can certainly cross-examine them about, but just a general question about what the parents were doing, probably meaning their involvement. In a case with allegations, not confirmation of an extortion, allegations like this one, and the parents couldn't consent to the behavior that's alleged, is what I said. You can't consent to sex and all that with a minor. So it really doesn't have any relevance. This is her speaking. So that's not going to be admissible just generally about the parents. But if the allegation, which is what I understand it to be, is that the particular Jane Doe witness were part of this plan, you can certainly ask them about that. Meaning, yeah, you can ask her or somebody directly about this plan if they were involved in this plan. Okay, so it can't be any kind of hearsay, anything like that. Like I say, I don't think you're that far apart on this, so I think I got that right. Farinella, Your Honor, I would like to ask that we be, Becker, Judge Farinella, able to flesh that out, meaning they want to get up there and put their narrative together based on what they found in discovery to try to have some type of the narrative to say that an extortion went on. Doesn't mean that it did happen. These are their allegations. This is a defense they tried to put on. Right? Let's keep reading. She said, I'm sorry, the judge, I'm sorry. In what form would it take? That's my question. Meaning, the form means what type of questions will you be asking? That's what she means. They are not testifying. Farinella, well, in terms of offering a defense, see, this is all part of their defense and extortion. And remember, as we saw in the motion of limine filed by the government, they were saying that it was that whole defense about extortion had something to do with Jane Doe number 1, I think 4 and 5, and that the parents knew about the sexual activity because it was an extortion. That's how you know it was a defense, just a defense. Hold on, let's keep reading. It says, let me go back. It says, well, in terms of offering a defense, Your Honor, depending upon the witness's testimony, not no text messages, no other type of evidence, the witness's testimony, what's elicited from the witness and what the witness says, it could be very relevant to the defense. Defense. And if in fact the defense should have available to them the possibility of calling one or either of the parents, if in fact there is information that's testified to, that goes to the actual defense. Meaning, if there is some information they flesh out, I'm using his word, they can call it the parents. Because now they got somebody linking an extortion to the parents. Put their ass on the stand. Okay. I mean the parents. Judge, I want to stop you. You're not objecting to calling the parents, are you? The prosecutor. I can't imagine what the parents could testify to that is relevant to Mr. Kelly's defense. So on principle, no, I'm not objecting. But I think they would need to make an offer as to how it's relevant to the charges. The judge. Well, I think they did make an offer that, and you'll correct me if I'm wrong. The offer is that this is all an orchestration by the Jane Does and their parents to frame, to use the right word, Mr. Kelly, and to get money out of him. Do I have that about right? Blank Becker, yes, Judge. Farinella, that's what the motion argues, Your Honor. Judge, well, I mean, Farinella, or that's what the motion, yes, that was. Judge, perhaps you'll get a witness that will come and admit that in court. I don't know, but if there is a witness to be had and can give relevant, I mean, it's like anything else. You'll make an offer of proof. I mean, you got to prove it in court. I'm not precluding you from doing that. Probably because there was none that says an extortion took place. You see, she was open to it. Where am I? I am precluding you from, I think it would have to be hearsay evidence. Like I told you earlier before I read this. Have to be hearsay evidence. Now, hearsay evidence have to be offered up to the truth of the matter. That's how that works. Like I say, I don't think you're that far apart. You'll be able to cross-examine the witness on this topic, so with obviously appropriate questions. We just have two left. Let me see. Okay, so that's evidence. So they weren't connecting the text messages to an extortion. They were trying to do what defense attorneys do. Use what they have in discovery, put it together to give some type of picture as if an extortion happened. They probably could have used that to link it to show that, well, and since it happened like that, it's more likely than not that R. Kelly isn't guilty of that element of inducement, enticement, coercion, whatever. You see how that lays out? You see, I just put that together. I don't have no evidence of none of that. This is how that works. Let me see. Hold on. Let me see something else. Just 1 minute. I mean, at this point, it's getting really confusing. Hold on. Okay. Let me see. As government has proper for their representative direct evidence. Right. Hold on. All right. Okay, John Doe number 17. Hold on. Directed. Okay. Okay, wait a minute. 17, 1, but this rule. Here's direct evidence. It's a mess with Jane Doe. Jane Doe number 17. Let me say this, John. I don't think the evidence is direct evidence. So as you see, I'm going through it right now to make sure. This lady, the judge spoke about direct evidence all through this. There was no direct evidence about no goddamn extortion. It was only a defense narrative, if you would. That's all it was. Evidence method participant advised. Hold on. I'm just seeing, making sure I'm scanning for direct evidence. Certainly. What was this about? The category evidence. I don't think I took part. Okay. Did I read this part? I don't know if I think I read this part. Let me put it back on here so y'all know I ain't fucking around. I'm pretty sure I read it, but let me put it back on here to show you that the judge said no direct evidence. Right here. I'll reread it. So it's certainly appropriate if you know with a good faith basis to question the witnesses, whether the witness participate in such a scheme. That's certainly appropriate, but sort of general question about what their parents did is really not. I mean, there is no direct evidence of it. No direct evidence. If there was, the text messages, insert the text messages. That's where that would have been. When you get a batch in discovery and something exculpatory, you use that to craft a defense. Now, you do the best you can with it. But the prosecutors, you saw them jumping in trying to shut it down. They weren't trying to shut it down because it was truthful. And I don't know how many times we got to say this. Just because it's on a filing, whether it's the prosecutor or defense, it doesn't mean that it is factual until they bear it out in court. Flesh it out, as Farnell said. Bear it out. I think in one of the prosecutors' filings. And supported by some type of evidence that makes a concrete statement that an extortion happened. But as you see, the defense was using Jane Doe number 1, 4, and 5. Now, what's the probability that Jane Doe number 1, 4, and 5 parents at some point in time, all at one point, they say Jane Doe number 1 parents got together and said, we want to extort R. Kelly. At another point in life, Jane Doe number 4 parents got together and said, oh, we want to extort R. Kelly. Another point in life, Jane Doe number 5 parents said, oh, we want to extort R. Kelly. What's the likelihood of that? What is the probability of that? God damn, we done said that they damn near I don't want to call them bad parents because I don't know like that. But they definitely missed some mishaps. Definitely some shit I wouldn't have done. And most of the people wouldn't have. And if people on the come up or whatever, some people have that hustle mentality. So they coming up with deals and shit like that or whatever. But J-Bo in her writing said the daughter didn't tell her mother. The mother didn't encourage the daughter to have sex. If this whole thing was an extortion and a setup and all of that, that's exactly what that parent would have done during them text messages. And it wouldn't be no laughing matter. This is common sense. It's like, get the help you need because this ain't that serious. I mean, I don't know if you're having flashbacks or what. I don't know what the fuck is going on. People are allowed to say they need more information. People are allowed to say, well, it looks like what it looks like. And it's okay. Can't tell people what to say and how to feel and because you all, get some help. Don't make no damn sense. I thought that the smoking gun was, I'm like, well, shit. This don't make a bit of sense to me. You have to put all the shit together, not little bits and pieces and all that. And then you got to know what you're talking about. When you're trying to second guess a defense or what happened or whatever, you got to know what you're talking about. Now the judge done weighed in, the prosecutors done weighed in, and defense tried to do whatever they tried to do. And that was shut down. And that's more than my bitch ass and the rest of y'all could ever. It is what it is. I just don't get it. You can't make motherfucking lemons and turn in the goddamn water or whatever. You extracting just bits to make a narrative. You got to look at the whole thing. It's a whole situation happening. And if you don't know how to read what's not there legally, you're not going to get it. That's just what it is. I have no idea how these text messages get links back to extortion. We don't went through this. Damn, I think everybody can admit. Are they the greatest parents? No. I even went and said, well, it looks like to me with this joking and shit like this here, if something would have went down, it wouldn't have been, they wouldn't have, it could have been maybe upset, but it wasn't going to be no punishment to be had or whatever. I won't even think, they're probably, okay, well, especially if she's already been sexually active and she's almost close to 18. Now, I don't know that to happen. I don't know nobody's feelings. That's just my personal perspective. But my legal perspective, and I'm looking. That lady said in her file that, let me drop this link. Because I don't like to talk shit and nobody can talk shit back to my bitch ass. Let me drop this link. That nobody, you look in her in J-Bo's filings, it says it was witness testimony with regard to extortion. So given the place where that footnote was, I think that they, like I said earlier, just a few minutes ago, that they were going to say, look at this extortion. Okay. So it would make sense that it was Jane Doe number 5 enticing and inducing and whatever Mr. Kelly. Instead of the other way around. J-Bo just said she could have used those text messages to prove that, just that last part. I connected the extortion part onto it because I'm looking at where that was placed, and you got to think about it. These are two sets of attorneys on this case. One set was dealing with that pretrial that I just read. J-Bo was dealing with the post conviction motion. There was going to be two different legal theories. I'm connecting the two. So that's my legal theory. It's the third. But the judge herself said there was no direct evidence. That should kill it right there with the extortion. Because she looked in it in the discovery too. This was going to be a whole bunch of witness shit. So the text message is not even in there. This is a bunch of witnesses with regards to the extortion. You can't link those text messages to that. Just get a banner, some signs, some shirts, and say they're bad parents. Sell them. God damn. Let's do that. Let me hold on. I mean, it's just crazy to me. Crazy. Oh, God. Let me see. Let me see. Happy Memorial's Day. Let me see if I have any questions about what I'm talking about. Holler at some more people. What's good with it, James Haddis? Boston, I'm in love with love. Girl, Melanie. Leslie Jennings, I think I got you earlier. Over. What's good with it? Over. Loves. Hot Rod in the building. Queen Diva. Let me see. Did I want to correct from that? They're talking about the Africans. Let me see. What's up, Danny? Hey, Danny. Hello, Danny. Hey, Danny. Hey, liar. Child, it's the hey, purple. Lisa. Yeah, time for all that. Let me see. Okay. All right. Is it at least crystal clear? Cause I hate for shit to get all confusing and shit. It's like, what's the problem? I mean, you have to know that when that shit hits discovery, when it's discoverable, that shit hits discovery, right? You get to draft you if you find anything in there to make up a defense or whatever, or get your narrative going, or get some shit that you think is gonna stick or could work, then that's what you do. That piece of it would have been to increase reasonable doubt. That's all that was. As you saw in Darryl McDavid's attorney's filing, he said that J Bo submitted all this shit and without a shred of evidence. You could do that. And just because it's the government, that doesn't mean that just because they put it in discovery, that it's going to bear out to be factual. No. Exculpatory doesn't mean that it exonerates your client. Exculpatory evidence means that it could exonerate your client and you have a decision to use it or not. But it got to be admissible. And when you get it into court, if the jury buy what you sell, then that's what they buy. That's what it means. Shit. That's all it means. What's good with it? What's good with it? Having to
Hey,
work?
lady, just stopping
Hey.
through for a minute to say how you doing. I've been busy and missing. Well, I can't say I've been missing nothing because I see it's still some crazy stuff going on. But
Oh yeah.
you spot on. I love you reading that paperwork and breaking it down because it seems like a lot of people read stuff and I don't be seeing what they be talking about.
Right. Yeah. But you have to go and draw for so many places when you are
It's a
second
lot.
guessing. Yeah, you second guessing
Yeah,
somebody else's work. You know what I'm saying? So you have to go and
yeah.
draw from so many places, right? And I mean, I just thought,
It's a
I
lot
was
of
like,
layers
oh
to this case, and I feel like really and
yes,
truly all of us are just getting an outline. There's so much that we don't know and that we might not never know.
right. We might not know, and I'm the type of person, and if I don't know for sure, I'm definitely not saying it. That's just correct.
That's
If I
me.
don't
I'm
know
just
for
sitting
sure,
back in a cut. I'm not gonna speak because you just never wrong. I'm not about to put my foot in my mouth and nobody else's. Just
right? And then you
it's a
got to
lot.
moonwalk like Michael Jackson to get up out of it.
Right, right. It's a
Yeah,
lot.
but
I sh-
it's a lot. It's a lot, but I thought we had done separated, you know, the extortion part the um from the text messages, although they could have crafted a defense that could have connected them all together, and
right.
but I mean, but those text messages don't have nothing to do with no goddamn extortion. Just don't have nothing
No,
to do with
because
it.
there would be if there was some type of extortion, why wouldn't R. Kelly file charges against somebody trying to extort him? That doesn't make sense to me right there. Why if people were trying to extort you, because I hear that a lot from a lot of folks. Why didn't
Yeah,
he ever file press charges at anybody and sue anybody for trying to extort him? There's gonna be a paper
right,
trail somewhere.
right, right. Exactly.
Somewhere.
Exactly. Now there would be some text messages and some messages of that. Where is that? Where's that
Right.
part? It's not
And that
nobody
has
no
to be proved. I remember hearing
right,
the father, Mr. Clary, say that they did send an email about doing a deal and there was
yeah,
never a response and the government checked their computers. They checked their bank accounts and all of that stuff. So I'm
right,
just like, if you're gonna throw it out there, it has to be proven, and I haven't seen any proof of that yet. And
yeah,
again, it's a lot of stuff that was redacted. I think we're all
yeah,
just getting an outline, so there's gonna continue to be confusion. We may not never know everything that happened, but I
Yeah,
know what I saw
exactly.
in that video.
Right.
He guilty of some things. He may not be guilty of everything, but he's guilty of something.
Right. And see, and the
It,
redactions are just like identifying information and that type of personal stuff. The
protecting the
body of,
people.
yeah, I mean, they will give you, they're going to outline, give you like that type of stuff, for as emails and things, and they'll just, if they are going to include it. But that's,
Right.
and you brought up a good, I mean, that's good. Where is the proof that an extortion went down?
Took
As far as,
place.
yeah, because, and it was, should be some type of language.
Yeah.
You know what I'm
I'm
saying?
like,
It should be some
anybody
type
can
of
say
language.
anything, but if you can't prove your narrative that you're trying to run with, what's the point of just keep throwing stuff out there and saying it? And there has not been any, we haven't seen any concrete proof or whatever. At this point, I don't need to see anything. I'm just like, it is what it is. It's gonna be what it's gonna be. That's how I feel at this point. Man, we've been looking at this shit for 3 years, and it's
Right.
not gonna stop. It's only
It's
gonna
not.
get even more complicated.
Like proving you correct, but and your testimony is right. That's what I tell you. Testimony is evidence. Testimony is evidence. But when I'm talking about what these people are looking at, I'm talking about like physical proof, direct evidence, as what the judge was asking for, saying that there's
Right.
no direct evidence of it, meaning something that says, listen, if you don't give us this, we are going to do this. That's an extortion language. That's extortion language.
Right.
That's what I'm
Right.
looking for. If you don't do this, we're going to do that.
And we haven't seen any evidence of that. And then they didn't even put any people on the stand on his side that could, like she said, testify to this extortion and show proof.
Right. Exactly.
So that really needs to go out the window. Nobody could come testify about it, and there was no proof shown that it happened. It's all
It's yeah. It's all you went out, Melanie. It's all looks like. I mean, look, I mean, you got to do, y'all got to think about it. You got to do something to defend your client. And if you look at that discovery and put something together, some patchwork, as Jeremy Davis said, J-Bo be doing, and come out with something that you think gonna convince that jury, that's what you're gonna have to do. That's what you're gonna do. Melanie, you went out. And that's just all to it. But you see, this about that extortion is all testimony. They didn't say they had nothing direct. Even, and here's another thing. Someone's testimony could be direct. So that's saying they don't even have somebody that's getting up there saying, like, I was involved in it, or I was there when it happened. So, oh, you lost the sound. I mean, like when we get all this shit separated and stuff, we done moved on and moved. Like, I don't like to confuse the situation. I don't like that. You got to look at all the parts. And when you speak convincingly to some of these people or whatever, they're going to take it as fact. And it's not facts. God damn. So, but anyway, that's all I wanted to get off. I'm probably going to go over there to Levi's. I don't know if he's dropping a link or whatever. But you got to put up all the pieces. When you call yourself second guessing what's in black and white, you better know how to what? Dissect what's there and what's not there. You got to do both ways. what's in black and white and what's not in black and white. And how they grouped it together, how the prosecutor grouped it together, you could see that it was a narrative that the defense was going with regards to Jane Doe number 1, 4, and 5, whatever they Atmos read. So is there some text messages and shit with other Jane Does that the prosecutor reference in that section? No,
My
it's a
bad, my
defense.
sound went out.
Yeah. So, honey, but I'm
I'll
finna
be
go and get
glad
off.
when this stuff start going over. I'm glad I caught you for a second. I've been busy and just running around. I'm gonna have to message you because I haven't really seen a lot of anybody's lives, but I know it's a lot going on. I just got on here today trying. I'm like, whoop, whoop, scoop, scoop. I can't. I don't even have the attention span to pay that much attention no more. It's
Yeah,
wearing me
right.
out. Wearing me out.
Okay,
There's too
Red
many
Bunny.
people putting spins on it.
Yeah, it's just spinning and spinning. And I like to, and I know, everybody, we all co-workers. I like to call
Right, right,
co-workers. And so when you get it, clear whatever, you just move on to the next thing and whatever. I don't like to get
right.
it, go back and get it all, crossed up
Twisted.
and whatever, what I'm saying. It's good to reference the paperwork, but that's what I reference too, the paperwork, but all of it,
Right.
not just
And
one
everybody
part.
has a different interpretation, and you can tell
Right.
it's obvious. People be saying stuff that you don't see and just putting a little twist on it. I'm like, oh yeah, I'll come back and wait till we get closer to the sentencing day to see how that go. Take me a break and see what's going on in August. And hopefully he gets a fair trial. I don't want to see anybody wrongfully, whatever. But again, he may be innocent of some things, but he's definitely guilty of a lot of things. Pray
Right.
for him. That's all the fans pray for him. If you're going to support him regardless, support him. Don't fight about it. Support him
Right.
any way you can. He needs all
Right.
the prayer in the world. And he does need help. He's got a problem. He needs to get help. That's it. It don't have to be nobody don't have to be fighting and trying to act cutthroat about it. It's nothing. You finna go over to Levi's channel, you said?
Yeah, I'm gonna go over there for a minute. Yeah,
Okay.
I
Well,
am.
like I said, I was stopping through to say hey. It's been a
But
busy, long weekend. That little child turned 3 yesterday with her saucy self.
oh,
I put a bunch
happy
of videos out
birthday.
there. Yeah, 3 going on
Oh,
33.
oh, I can imagine. Girl, I got a
Yeah.
step granddaughter. I
How
got a step.
old?
She is 3.
Oh
She is
yes, they
3.
something else, honey. That
Mm-hmm.
child, it was her birthday, and she was telling folks to go away and crossing her arms and pouting. I'm like, oh, you acting ugly
Oh
on your birthday.
no.
She wanted her way. I'm like, she's such a spoiled brat, but the weather turned out nice and she had a good time. When you have some time, you have to check out her little pictures and videos. You're gonna laugh.
Oh wow.
You'll
Yes,
definitely
child.
laugh.
Yes.
Yeah.
Honey, them little
Well,
kids. Girl, let me tell you something. For her, I brought her clothes to last her for from her little baby birth to like 2 years old. And
oh,
child,
you cleaned up.
oh girl, I always do. Don't baby. She like her first. I brought her. I think it was like 30 some pair of little shoes.
Wow.
Yes, all kind of outfits, whatever. Shit, these people dock so much. Maybe I'll scratch her face off and show all these outfits. And it was so funny, right? Because
Or you
because
know
we
what? Catch us on our other side. We got an
oh
inbox
yeah, yeah,
you can
yeah.
message
On the
us.
other side, yeah, I forgot about that.
Yeah,
Yeah, I
catch us
get
on
on the
the
other
other
side.
side.
Yeah. And honey, I was her little daycare, right? Uh, I'm worried about. I'm like, well, do they offer a best dress up in the daycare? I said, if she don't get it,
Okay.
I'm gonna turn it out.
It's
And
so easy to go overboard and spoil them and shop for
it
them like that because
is,
I'm guilty. I'm very guilty.
it is,
All
it
of us
is,
are. They are
it
so
is.
much joy. Well, go help Pastor Levi over there, and I'll try to catch you when I can. I just happen to be off today. It's back to the grind tomorrow. I
Okay,
enjoyed my
honey,
3 day weekend.
I message you on that new one.
Okay, I'm gonna
Okay,
message you back. Everybody enjoy the rest of your Monday. You guys have a good day, and I'll talk to y'all later.
all righty, ma'am.
Alrighty, bye
Thank you,
bye.
ma'am.
Uh-huh.
Oh, you know, and I also not you, but I also heard the other lab. I heard when Kelly and Levi was on there. I heard Kelly say non-legal RICO. I think he meant non-economic RICO. I think that's what he meant. There's no such thing as a non-legal RICO because that's incorrect just by nature. But I think it's non-economic. I think he meant non-economic RICO. Maybe I'm wrong. I don't know. But anyway. So I'm going to go ahead on over there to Levi for a minute. Then I have to get back to my day. All right, y'all. Thank y'all for coming on through and hit that like button. And if you didn't, shit, I understand. Oh, shit. All right, y'all. Yeah. Oh, you shop for your grandson, honey. When I tell you, let me tell you something. That little girl had every kind of dress, outfit, polo, every goddamn thing, honey. And I told my child, I said, I hope they don't think I'm crazy. Cause when I came in there, I came loaded. And they were just pulling out shit. They was like, well, like how much is it, girl? I got you covered. I got you covered, honey. Oh, it looks so cute in the little outfits, honey. Oh, child. Mm-mm-mm. And then I like to look for art shit too. I'm gonna keep you in season. I'm gonna keep you, down with the stuff. Child, oh, child, yeah, but that's my little step grandbaby. Anyway, all right, y'all. I thank y'all for coming on through. Hit that like button on the way out, and I will holler to the next live. Be good to yourself, be good to each other, and do something nice for somebody else. All right, y'all. Peace.